McDonald's. So here we are in court. We go to court, the judge says you don't have standing. We say yes we do, she says no you don't. We say yes we do, she says no you don't. And she finally dismissed our case with prejudice. So now we're appealing to the Ninth Circuit Court. Now this is a problem for us, it's a big problem, because here's how we had this planned. We approached the court under United States Code Title 28, Section 2284. And that says that any case that is dealing with lack of representation or dilution of vote must be handled by a 3-judge panel, because no single judge can be trusted with the vote of the people. No single judge. It's too precious. Your liberty is too precious to trust to a single judge. And a Supreme Court case, Shapiro versus McManus, not instructs, but directs every federal court judge to this behavior. And that is that whenever a case comes before you that is either lack of representation or dilution of vote, you have but one duty, one. And that is to appeal to the chief magistrate of your district and ask him for 2 more names. There is only one exception to that, and that is if you find the case to be frivolous or without merit, then a single judge may dismiss the case. Well, here's the problem that the judge has. We asked her in open court. Scott Staffney, our attorney, asked her, Your Honor, do you think this case is frivolous or without merit? Shapiro v. McManus. She says, oh, absolutely not. I think this is a very serious question and needs to be answered. Then she said to the state's attorney, Waters, she said, Mr. Waters, do you think this case is frivolous or without merit? Oh, absolutely not, Your Honor. This is a very serious question. So she admitted in open court that we made the bar in Shapiro v. McManus, and we deserve the 3-judge panel. Now here's the good part for us, Title 28, 2284, and we knew this in advance. This is why we did it this way. Says that the result of any action involving a 3-judge court, primary jurisdiction for the appeal is the United States Supreme Court. There is no cert process. Everyone's entitled to an appeal. So in a 2284 case, you skip the Ninth Circuit and you go straight to the Supreme Court and they can't say no. And we got this plan from the Abbott versus Evenwell legal team, and they did it. They actually did that. And they went straight to the Supreme Court. We did everything they did. We did everything they asked us to do in order to make this plan work. But here's the problem. What our judge did was, when we first went into court, she right away gave us the 3-judge court. Okay, well, I'll get a 3-judge court going. And a week later, she changed her mind. Now our attorney, Scott Staffney, Gary Zerman, and Judge Alex Kaczynski, who used to be the chief magistrate of the Ninth Circuit Court, he's probably the only conservative on the court, truly, they said, well, wait a minute, Your Honor, in the annals of American history, there has never been a judge that issued a call for a 3-judge panel and then asked for a do-over later. You can't do that. There is no legal process for you to change your mind once you ask for a 3-judge court. And here's what we think happened, because the judge admitted it. She said, well, I called for the 3-judge panel, and then I had communication with the Ninth Circuit Court, and they advised me not to do that. Well, think about it. She asked a court that had not been briefed on the case, did not know the merits of the case, had never read the case paperwork, weren't in the room when the case was being argued, and based upon their advice, she changed her mind. Well, we think that's not only illegal, but it's unconstitutional. Now, here's where it created a problem for us. It's about a $100,000 detour. We weren't planning to go to the Ninth Circuit. We were planning to go from trial court straight to the Supreme Court. So now, we're $400,000 into this thing, and we're not going straight to the Supreme Court like we thought we would. We're in the Ninth. What we hope for in the Ninth, and it hasn't been calendared yet, but it will be soon, we hope that the Ninth Circuit will realize that Judge Mueller acted inappropriately and unconstitutionally, and they will remand the case back to her and instruct her to call for the 3-judge panel, and then we're back on plan. Now look, we are going to lose in front of Judge Mueller. We already know that. We knew that right from the beginning. We knew it before we filed the case. She's a Democratic operative. She's a buddy of Darrell Steinberg's. Her family ranch is right next to Jerry Brown. She was on the Sacramento City Council. She went to law school in San Francisco. We knew we were going to lose in front of her, but our justice won't come from her anyway. It'll come from the United States Supreme Court. And look, whether we win or lose in front of Mueller, if we win, the state is going to appeal to the Supreme Court, and they can, 3-judge panel. And if we lose, we're going to appeal to the Supreme Court, and we can, 3-judge panel. So our only hope for justice is in front of the United States Supreme Court. And remember also, once you go to appeal, facts not in evidence can't be argued. So if the state doesn't say, no, you're wrong, and the state's never said this, they've never said, oh, you have plenty of representation. They've never said that. Well, if they don't make that argument at trial, they can't make it in front of the Supreme Court. It's too late. So we will have a case that essentially is unopposed because we're the only ones arguing the merits. They're just saying you don't have standing, you shouldn't be here. They're not even saying we're wrong. They're just saying you don't belong here. So that's where we are with the CFR case, and we need your help. I mean, we've got $30,000 left. We need $230,000 at a minimum. And a lot of us are giving everything for this. If you can give something, please do, because we won't win. And, you know, there were $1.2 million in Jefferson. I think it was Patrick that said if everybody in Jefferson just gave $5, we'd win. But we're not successful at that. There are